Hi, it's the Florida Law Guy. Today on Making It Simple, I'm going to talk to you about pretrial release. Under Florida law, when a person is charged with a crime, they are entitled to release prior to trial on reasonable conditions, with one exception. They're not entitled to pretrial release if they're charged with a crime in which they could potentially get the death penalty or life imprisonment, if proof of guilt is evident or the presumption of guilt is great. So, although it may be difficult, a lawyer for the defendant can still argue for the release of defendants charged with these serious crimes if they can show the judge weaknesses in the state's case. When a judge decides what conditions to impose for pretrial release, the judge considers three factors. First, what are the minimum conditions that can be imposed to protect the community from risk of physical harm? Second, what are the minimum conditions that can be imposed to make sure the defendant shows up for court? And third, what are the conditions of release that protects the integrity of the judicial process? However, if the judge determines that no conditions of release can achieve these goals, the judge can deny pretrial release. Now, the least restrictive type of pretrial release is called a release on a person's own recognizance, or ROR. When a person is released ROR, they don't have to pay any money to get out of jail. They just make a promise to show up for court, not commit any crimes, and follow the rules or specific conditions set by the judge. The next least restrictive type of pretrial release is called an unsecured appearance bond. Again, in these cases, the defendant does not have to pay anything to get out of jail. However, by signing an unsecured appearance bond, they are obligated to pay money as bail if they don't show up for court. Finally, there is bail. Let's say the judge sets bail at $10,000. In order to get out on $10,000 bail, a person would have to deposit $10,000 with the jail. Now, the purpose of bail is not to punish, and the defendant gets that money back once the case is closed, regardless of whether the defendant is found guilty or not guilty. As long as the defendant shows up for court and does not break any rules or conditions of pretrial release, they'll get the $10,000 back. However, if the court imposes a fine or court costs as part of the sentence, the judge could immediately apply the bail money towards those fines and costs. So if a person has a $500 fine, they would only get back $9,500. However, if a person does not show up for court, or if they get into trouble while out on bail, the judge could revoke the bond, issue a warrant, and the defendant will lose the bail money. Besides setting bail, judges can set other restrictions as well. The most common is for the judge to order the defendant to have no contact with the victim of a crime, especially in domestic situations. Judges can place restrictions on travel, association, or where the defendant may live during the period of release. For instance, the judge can say the defendant can't leave the county or state, or forbid the defendant from going to bars or consuming alcohol while out on bail. The judges can even order that a defendant can only be released from jail if it is into a drug rehab center. It's completely free, so please support my mission to help make Florida law simple for the public to understand by liking and clicking the subscribe button. The way YouTube's algorithms work, the more likes and subscriptions a channel gets, the easier it is for others to be able to find it. So by subscribing, you'll also be helping others. Thanks for watching. See you next time.